Whether you wear a badge or not, if you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, a police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report.
Hello, I'm Don, and this is the Conditions Report. If you've already been listening to the show, then you know the premise. And if you're new here, here's what you need to know. This is the weather forecast for street cops, detectives, and admin, what's coming and what's changing in the environment that we work in. And before we go any further, a quick disclaimer. I'm not an attorney, and nothing discussed on this show is legal advice. I'm not speaking on behalf of any government organization or law enforcement agency, and the views expressed here are those of Forecast Securities Group and myself, and they're an exercise in the protected American free speech. If you need legal advice or guidance specific to your agency or jurisdiction, you should consult a qualified attorney. This podcast is for educational and informational purposes only. We're not here to judge officers involved in incidences or second-guess decisions with the benefit of hindsight. The point is to learn from the hard-earned lessons on our behalf and improve as a team. This is Conditions Report Episode 20, Rahimi's Reach, Federal Firearms Orders, and California's Preventive Prohibition. Following the United States v. Rahimi in 2024, which upheld 18 U.S.C. 922 G8 against the Second Amendment challenge, the central question for California's Gun Violence Restraining Orders, or GVROs, under California Penal Code 18100 to 18205 is whether their procedures align with the historical traditions of firearms regulation as articulated in New York State Rifle and Pistol Association versus Bruin in 2022. In Rahimi, the court emphasized that temporary disarmament is constitutional when a court order after notice and adversarial hearing finds a person poses a quote-unquote credible threat of physical harm. California's Gun Violence Restraining Order framework, however, authorizes ex parte or emergency orders based on preliminary affidavits before such a hearing can occur. This procedural difference raises unresolved questions under Bruin about whether preventive non-adversarial firearm seizures satisfy the historical analog test or impermissibility infringement on the Second Amendment rights. California's legislature defends GVROs as narrowly tailored, citing their role in preventing foreseeable gun violence, where waiting for a post-incident judicial finding would be, quote, too late. Yet, because Rahimi did not address ex parte orders explicitly, federal constitutional validation remains uncertain until courts determine whether early-stage GVROs provide the basic due process protection the court viewed as essential to disarmament. Situation brief. Tensions escalated in a parking lot of an Arlington, Texas restaurant one December evening in 2019. Mr. Rahimi and the mother of his young child had met for lunch. An argument flared. Rahimi grabbed her wrist, dragged her to the back of his car, and shoved her inside so hard her head struck the dashboard. When a bystander watched, Rahimi paused, reached under the seat for a pistol, and fired as she fled. He later called and warned her not to report the crime. Undeterred, she went to court, and after Rahimi received formal notice and a full hearing where he could present evidence and contest the claims, a Tarrant County judge issued a 2-year restraining order. The order contained the exact finding required by federal law. Rahimi, quote-unquote, represents a credible threat to the physical safety of his intimate partner and child, prohibited threats, contact, except for child-related matters, and required him to surrender his firearms. Rahimi signed the consent order. He did not honor it, though. In the months that followed, he approached her at home at night, contacted her through multiple social media accounts, threatened another woman with a gun, and police linked him to at least 5 separate shootings, firing into customers' homes over a drug dispute, shooting at another driver in a traffic incident, charging a weapon in a residential neighborhood, and chasing a truck on the highway and firing at it, and pulling a gun in a burger restaurant where a credit card was declined. Officers executing the search warrant found a pistol, a rifle, ammunition, and a copy of the restraining order itself. And federal prosecutors charged him under 18 U.S.C. 922 G8. Rahimi moved to dismiss this claim, stating that it was unconstitutional on its face, and the district court denied this motion. While this case was on appeal, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin, a 2022 decision that struck down New York's quote-unquote proper cause requirement for concealed carry permits and announced a new test. Any firearm regulation must be consistent with a nation's historical tradition of firearm regulation, and the Fifth Circuit applied that test and reversed, holding that the government had not shown 922 G8 had proper historical analog. The Supreme Court took the case in June of 2024 and reversed the Fifth Circuit and upheld the federal statute as applied to Rahimi. Chief Justice Roberts wrote that when a court finds a person poses a credible threat after notice hearing, temporary disarmament is consistent with the Second Amendment. Now picture this: a typical morning in a place like San Francisco. A coworker or a family member submits an affidavit to a court claiming an individual poses a quote significant danger of causing personal injury with a firearm. Under California Penal Code 18150, a judge can issue an emergency gun violence restraining order on the very same day, ex parte, without notice to a person, without any hearing, and firearms must be surrendered immediately. A hearing is then scheduled within 21 days, but the guns have already been taken. The procedural foundation of the two orders could not be more different. One rests on a tested judicial finding of credible threat after both sides of the argument have been heard, and the other rests on an untested preliminary affidavit or even potentially a false claim, and one carries the legitimacy of full adversarial process, and the other carries the arrogance of hearsay. These contrasting foundations define the environment California officers now face. Current conditions. 18 U.S.C. 922 G8 is a federal criminal statute that applies only when three requirements have been satisfied. First, the person must have received actual notice and an opportunity to be heard before the order was issued. Second, the order must restrain harassment, stalking, or threats against an intimate partner or child. And third, the order must either contain a judicial finding that the person was, quote, represents a credible threat to physical safety, unquote, of the protected individual, or explicitly prohibit the use, attempted use, or threatened use of physical force. Only when all three conditions exist does federal law make continued firearm possession a felony. In Rahimi, the Texas order met every condition after the full hearing. The Supreme Court therefore examined whether this kind of targeted post-hearing restriction had roots in the nation's historical tradition of firearm regulation. The court looked at the surety laws of the 18th and 19th century, mechanisms that allowed magistrates to require anyone suspected of future violence to post a bond guaranteeing good behavior. Failure to post a bond meant jail, breaking the peace meant forfeiture, and the court also examined, quote, going armed laws that punished anyone who carried weapons in a manner that terrified the public, with penalties including forfeiture of the weapons and imprisonment. Both sets of laws were triggered only by an individualized finding of threat and were limited in duration. The court ruled that 922 G8 is, quote unquote, relevantly similar to those historical measures in both purpose, preventing demonstrated threats of physical violence, and method, judicial finding after process, temporary restriction only. Because the statute is constitutional as applied to someone like Rahimi, whose order rested on a credible threat finding after notice and hearing, his facial challenge failed. The Fifth Circuit had demanded an exact, quote, historical twin and had focused on the hypothetical cases. The Supreme Court corrected that approach and upheld the federal statute. California's gun violence restraining orders operate on a completely different foundation. Under Penal Code 18100 to 18205, any family member, household member, employer, coworker, school employee, or law enforcement officer may petition for an order by filing an affidavit alleging the person poses a, quote, significant danger of firearm injury to self or others. If the judge finds immediate and present danger, an ex parte emergency order issued the same day without notice to the subject and without any hearing. The firearms must be surrendered immediately, and a hearing could be held within 21 days. after which the order can last up to 1 year and can be renewed. The legitimacy gap is pretty clear. The federal 922G8 order in Rahimi rested on the judicial finding of a credible threat made after both sides were heard. The California GVRO temporary order rests on the untested affidavit and an ex parte prediction of future danger. In 2024, Alameda County issued 128 gun violence restraining orders, 48 emergency orders initiated by law enforcement for immediate threats, 45 temporary orders, and 27 full orders after hearings, plus a small number filed by family members, coworkers, and schools. And these numbers reflect real use in a county that recorded 119 gun homicides last year. Yet the constitutional foundation differs sharply from the Rahimi order. One rests on evidence tested in open court, and the other rests on preliminary allegations that have not yet survived cross-examination. The Supreme Court in Rahimi did not decide the constitutionality of ex parte red flag orders. Its reasoning, however, highlights the distinction. Disarmament turns on whether the court has made specific tested findings of a threat after due process. Where that finding exists, the restriction fits historical tradition. Where it rests on untested prediction, the legitimacy rests on different ground that remains uncertain under Bruin's historical analog test. That brings us to the leadership navigational aid. If liberty means anything at all, it means the right to tell people what they do not want to hear. George Orwell wrote these words in 1945 while preparing for the preface to Animal Farm, a satirical novel critiquing totalitarian regimes. He had watched governments suppress uncomfortable truths to maintain control, and Orwell insisted that real liberty includes the right to speak facts that authorities or public would rather not hear. This very same liberty protects what we do here on the Conditions Report. When we compare procedural legitimacy of 922G8 order that rests on a post-hearing credible threat finding with legitimacy of a California GVRO that's issued on an ex parte affidavit, we're exercising the First Amendment's protected expression. We're not judging officers, but we are laying out the constitutional terrain so every listener can navigate it with open eyes. A single leadership lesson every supervisor, detective, and street officer in California must carry forward. Legitimacy in enforcement flows from the verified judicial process, not from the urgency of movement. Let me explain what that means in a practical term for you as a leader. Federal 922 order carries the weight of a judge's finding of credible threat, made only after a person has received notice, appeared in court, and had the chance to contest the evidence. The hearing is a constitutional safeguard the Supreme Court in Rahimi said makes the restriction lawful. A California GVRO emergency order, by contrast, can be issued the same day an affidavit is filed, and before a person even knows about it, and before any evidence has been tested. The guns are removed on the strength of an untested prediction of potential future danger. I disagree with the California GVRO approach in its current form. The reliance on preliminary affidavits without prior adversarial process creates legitimacy gaps compared to Rahimi's requirement for tested findings. That gap leaves officers in a difficult position, enforcing orders that may not yet meet the full constitutional standard the Supreme Court has signaled. But for now, hope lies in future rulings. Courts are still grappling with how Bruin and Rahimi apply to ex parte mechanisms like GVROs. The Ninth Circuit and others will likely address whether early stage seizures provide sufficient due process protections or whether stronger safeguards like mandatory pre-deprivation hearings in non-emergency cases are needed. Until then, leaders must navigate carefully. Make verification your standard. When an order arrives, look at it closely. Does it show post-hearing credible threat finding, or is it an ex parte GVRO? Document the basis. If ex parte, note the hearing date and ensure the subject is well informed of the opportunity to contest. Train your teams to do the same on every call. Build a checklist so no one enforces without confirming the procedural foundation. That habit protects your authority and the rights of those involved, and your team from challenges that turn reactive enforcement into principled action. Orwell reminded us that liberty requires courage to speak uncomfortable truths. The truth here is that procedural strength determines legitimacy. That brings us to the extended forecast. Digital records now preserve every threat, every affidavit, and every order forever. GVRO petitions will continue across California as awareness grows. Federal 922 G8 prosecutions will overlap when a qualifying domestic violence order does exist. And courts will keep testing whether California's ex parte mechanism satisfies Bruin's historical analog test, which is a two-part test. One, whether the regulated conduct falls within the scope of the Second Amendment, and two, if so, whether that regulation is consistent with historical tradition of firearm regulation in the United States. The forecast is simple. The line between legitimate restraint and presumption will be drawn by procedure. Train relentlessly on verification. Document every step. Act on evidence that has been tested, not on prediction alone. And operate within the confines of your own conscience. Enforce the laws that are required today, but never surrender your judgment to presumption. When an order's foundation feels shaky, untested, document it, verify it. Your conscience is the last line of defense for both the Constitution and the communities that you serve. As we close, let's remember the point of this show isn't to pass judgment or revisit decisions with the benefit of hindsight. It's to learn as a team and improve. We're all leaders, so keep the LNA in the back of your mind. The work is complicated and the environment is demanding, and none of us get it perfectly. Stay hungry, stay humble. I'm Don, and this has been the Conditions Report. Be the calm in the storm, the clarity in confusion, and always influence the weather.